Well, hello and welcome once again. Disability Law Show. John Scholes along with Tamar Agopian. We are back here to educate you and help you out. We'll go through that minefield of the term disability law and all that it encompasses. It's always an education over the next 30 minutes, so we're so glad you're here. A couple different ways to reach out to Tamar and her team right off the top. 1-855-821-5900. help@disabilityrights.ca would be the email address. We'll get to some emails a little later on in the show, and you can also simply go to disabilityrights.ca, the website. Lots of information to be had there and more contact information as well. Coming up in just a bit, 3 terms you must know, 3 LTD terms you must know and why. That's in a little while tomorrow, but we always start off with a success story. A week that was, pal. What do you got going on?
So one of the ways, the key ways that we resolve disputes for our clients, John, is mediation. And we talk about this, but we don't highlight it as much as I think we should. And so in my mind, I thought, let's start off the show talking to our listeners and our viewers about mediation. What is it? It is a non-binding settlement meeting. It's not done before a judge. Both sides, as in ourselves with our clients, agree with the insurance company to engage in this process, to get to sit down, to talk through the issues and try and get a resolution. And we have a very, very high success rate in resolving these claims for our clients very quickly, very expeditiously, because most jurisdictions across Canada have a mandatory mediation process, or at the very least, courts have encouraged the parties to have these processes, to have these discussions early. And it's a very effective tool. Now, unpacking this a little bit, what does it require? Nothing for my clients, guys. We do all the work. We will collect all the medical information that supports the mediation process. I will prepare a very comprehensive brief. I will advocate both in writing and orally at the mediation on behalf of my clients as to why they meet the test of total disability and why they're entitled to benefits throughout the period of time they've either not received them or have been denied. And of course, we have a key conversation around what does the future look like? Because John, the courts don't look into the future. If, let's say, a case were to go to trial and a judge were to make a ruling, hey, Tamar, we agree with you and your client that your client has been totally disabled this whole time. A judge can't look into the future. All a judge can do is effectively reinstate you, put you back on claim, and talk to you about historical benefits. However, in the context of a mediation, one of the critical things that we're talking to the insurance company about is, in fact, that future period. If my client remains totally disabled at the time that we're having that discussion at mediation, then inevitably we have to talk about the future, and we can actually optimize those dollars and get them up front. We actually get a buyout of the disability policy, sometimes for years and years into the future for our clients, and we get rid of the insurance company completely after that. And there's mutual benefit to that, because clients ask me all the time, why would the insurance company want to do that? Here's the key thing, John. They don't want a judge to look at these claims. They don't want a judge to critically look at what did the insurance company do and frankly not do, which is not paying benefits and potentially aggravating or exacerbating the health conditions that someone might have. And that plays into that buyout of the disability policy because the insurance company wants to minimize the risk of a judge ordering extra contractual damages, which is compensation over and above what you might get by way of benefits. So this is what success, I think, looks like in the context of a disability litigation. Very few of these claims ever see the light of day inside of a courtroom for all of these reasons and then some. The insurance company doesn't want an adverse decision. And frankly, the last few I can think of, at least in Ontario and a couple in BC, have all gone in favor of the claimant. So this motivates the insurance company to come and have a conversation with us early about resolving the claim. And it gives us a great leverage against the insurance company to get a huge buyout for the disability policy, get a bunch of compensation for our clients up front, and they don't have to deal with the ongoing adjudication with the insurance company.
A couple dumb questions. Is the client at the mediation, or is this just between you and the insurance company?
You know what? And it's not a dumb question at all, John. Right. Absolutely, the client is with us, and they are involved in the process in the sense that, you know, their presence is important. I think it's a lot of the times the first time someone from the insurance company has actually laid eyes on them. Because think about what a normal adjudication would look like. You know, you submit some paperwork, that paperwork is reviewed by an adjuster, that adjuster may or may not give the claimant a call, and then they make a decision. And look, if you've been on claim for a couple of years, perhaps that adjudication continues, but at the end of the day, very unlikely that the adjuster or the adjudicator on your claim has actually met you in person, has reviewed you, has assessed you, Maybe they haven't even had someone assess you on behalf of the insurance company. So when you get to the stage of mediation, it's not the adjuster, by the way, who attends on behalf of the insurance company. It's someone who's assigned at the insurance company specifically to deal with litigated claims. And that's fantastic because we're now talking apples to apples. Now we're talking to individuals and their lawyer, by the way, who know the law, know the risks around what might happen if a judge were to take a look at and critically review what the insurance company has done. And it affords them the opportunity to see firsthand what I've experienced with my clients, which many of them will say, Tamar, I have ongoing total disability. How is it that the insurance company is not approving and paying my claim? So it gives us the opportunity to advocate. It gives my clients to refocus on their health. And then we get to a point where we can achieve a resolution without going down the road of years and years of litigation, without going down the road of even having the judge weigh in, because the insurance companies know that that's just going to be a losing proposition for them, at least if you've got ST law behind you.
So take me through the day. Is it just you meet at a place with the lawyers? It's very relaxed. It must be a lot less intimidating than being in a courtroom in front of a judge.
It is, absolutely. And so, look, in the post-COVID world, we're doing most of these virtually. So we'll do it on a virtual platform. But yes, I mean, I think that in the pre-COVID world, that's exactly what was happening. We would get together in a boardroom. It would be myself, my client, the representative from the insurance company, and their lawyer. And then we would have a mediator, a neutral third-party individual who we've selected, usually someone who's very experienced in litigation disputes with disability, and that person becomes the go-between. But John, what's key here is that it's private and it's confidential.
Right.
So everything that's said and done in the context of these mediations is absolutely privileged. A court or a judge is not going to know the positions and the compromises potentially that were made in the context of a mediation, which again is really, really important because it promotes open dialogue. And that's what we want. We want the insurance company to get real. And I can tell you, they very often do in the context of a mediation, which is why we have such a great rate of success in getting these resolutions in those forums.
And you said this is mandatory in a lot of jurisdictions.
It is.
Ottawa and I believe Toronto and Windsor, as a matter of fact, and other places, right?
Exactly, John. So if you're in Windsor, you're in Toronto, you're in Ottawa, there are specific rules, civil procedure rules that guide all of our legal claims that are initiated in those jurisdictions that say within 6 months of the start of a legal proceeding, you have to have one of these mandatory mediations. And so it's excellent, really, really effective, but it answers this key question that I often get, Tamar, am I going to win against the insurance company? And I say to people, yes, you absolutely are going to win. But are you going to get a day in court? You don't necessarily want that. It can be risky. And in fact, you can leverage that risk against the insurance company by using the legal claim and these mandatory mediation processes to get an excellent result, buy out of the disability policy for a period of time, and close out the headache of the insurer.
Again, we always tell you to reach out to Tamar and her team anytime you want more information. How do you do that? Phone line is good, 1-855-821-5900, help@disabilityrights.ca. There's also a website we talk about on this show, Tamar. I know you're familiar with it because I guess not all of our viewers would know that in addition to the bulk of your work being disability law, you also dabble in employment law.
I do.
And that's the other half of the firm because there's so much crossover between the two. And we have this website, pocketemploymentlawyer.ca, which is really handy, and you've used that, right?
I have, and it's really a great tool. The first thing I will say about this tool, John, and for those who are not familiar with pocketemploymentlawyer.ca, it is completely anonymous. And so I absolutely understand sometimes people having hesitation to find out about their rights, but maybe they don't want to speak to us, they're not ready to have a conversation with us. This is an excellent tool. You can go onto the website, it's a plug and play type scenario, whether it's to find out if you've got a claim in respect of your long-term disability matter, or if you're trying to figure out, look, if I were to be packaged out or get a severance, what might I be entitled to? This is the website to go to find that kind of information. And look, if you want to take the next step after that and have a conversation with one of us, by all means, absolutely not a problem. But if you don't, you close out your browser, you're done, you get the information, and that's that. And it's a really, really good plug and play, super simple process to go through.
Always get a few emails on the show. Every week we're going to get to our first one. Again, help@disabilityrights.ca. Anytime you want to send one along, it might appear in a future show, right? Mallory, this time around, says, I've been on disability for over a year due to severe depression. A new doctor has taken over my treatment and suggested that there is a possibility I would be able to return to work in the future, but did not specify when. when the insurer has decided this is enough of a reason for me to begin a return to work program, but I don't feel ready?
What do you do? And so, look, Mallory, I appreciate the question because really you're experiencing, I think, what's happening right now, which is a pressure tactic from the insurer to try and get you back to work. No surprise there, because if they get you back to work, they don't have to pay you your disability benefit, okay? And so if you've got a new doctor, that doesn't concern me much. I think what's important in a scenario like this is to ensure that the new doctor is providing clear medical evidence to support the disability claim. You want to make sure that the new doctor has actually explained that they have not actually cleared you for a return to work just yet. And in fact, you want the doctor to also explain that you need ongoing treatment, what that might look like by way of a prognosis and a diagnosis. Because the insurers, you're right, are going to cherry pick. This is what they do, John. Yeah. They take the best pieces of information and they rely on those pieces of information to try and pressure people back to work. But if you haven't been medically cleared, I know it's hard to resist the insurer, but I don't like the idea of someone like Mallory putting herself back into a work setting when she's still on the path of recovery. She describes for us that she's been off for a year. It sounds like she's under appropriate care. And so if that's the case, and she in fact still meets the test of total disability, then she should be getting her disability benefits. And so look, can it be difficult in a situation like this? Absolutely. But you want to follow your own medical advice. The worst case scenario is, yes, the insurer may say, look, we think you're ready, so we're just going to cut off the claim.
Yeah.
Guess what happens then, though? Hopefully you're going to give me a call or someone in our team, and we're going to talk you through your options. But the worst case scenario is you do buckle to the pressure, they cut off your benefits anyway, and now you've taken 3 steps back from a health perspective, and your doctor says you went back too soon, and now you've prolonged the duration of your possible disability claim. Not a good situation for Mallory, and frankly, I don't like the idea of anyone going back to work before they're ready, and ready not only emotionally, but physically and in line with what the medical advice is as to whether or not she should do so.
Let's say you've got all those ducks in a row and even your medical team has cleared you to go back to work and give it a shot. Now, initially it took you a while to start getting benefits from your insurance company. Now you've gone back to work. It didn't go that well, so now you got to go back on claim. Is there a shortened period? Can you get back on claim after you decide to go back to work, even with your doctor's blessing?
Yes, you can. And so what John is getting at here, guys, is the recurrence provision. There is a section in the disability policy that says if your health prevents you from working and your return to work was unsuccessful, you've got a window of time in which you can reinitiate your disability claim. Usually that window of time is about 6 months from the end of a prior claim to the start of a new claim. And so if you have an unsuccessful return to work in that 6-month window, you can actually access your disability benefits once more without having to wait the initial waiting period, or what we call the qualifying period or elimination period. What you would do in a situation like this is you would just simply submit further medical information supporting that you need to be off again, have your doctors have that made clear and unequivocal, you submit that to the insurer, and the insurer theoretically should be starting up your long-term disability benefits once more pursuant to that recurrence clause.
And that is how that one works. Reminder, anytime you can reach out to Tamar and her team to clear any of the talking points we cover on this show, 1-855-821-5900. 3 LTD terms you must know. We're going to get to those, but we'll take a short break first, so stick with us. Lots more disability law shows on the way.
People think you should go to the government to get severance pay. EmploymentLawyer.ca says that is a myth. Government can only help you get minimum severance, but not everything you're entitled to. Always check with the employment lawyer first at EmploymentLawyer.ca. If your long-term disability claim is denied, should you appeal?
Appeals often fail because insurance companies control the process. So long as you appeal, you're playing by their rules.
You should never appeal the denial of your disability benefits. Appeals are just a mirage of false hope.
Don't. That's their process. Take it out of their hands and fight for your rights with our help.
Go to disabilityrights.ca. Discover your rights, fight back, and get what you're owed. People think their employer can make changes to their job. EmploymentLawyer.ca says that is a myth. Your employer can't change your pay, hours, or duties. You may be entitled to full severance pay. Always check with the employment lawyer first at EmploymentLawyer.ca.
And Welcome back. Thank you so much for hanging on. Disability Law Show. John Scholes with Tamar Agopian, courtesy Samfiru, Tumarkin LLP, the most positively reviewed law firm in the country. Do not ever hesitate to reach out to Tamar and her team, even if it's just for information, a bit of a chat. 1-855-821-5900, and email is help@disabilityrights.ca. We'll get to more of those later on, but I wanted to get to our topic for the day. Tamar, we could have done 103, but we got it down to 3 common LTD terms you need to know and why. We're starting off big. Total disability. Of course, you knew that was coming, right?
Of course I knew it was coming, because this is the million-dollar term that insurance companies have made billions of dollars upon, right? So what's total disability? Total disability is really the test that you need to meet in order to qualify for disability benefits. And this test is, by the way, the same whether you're looking for short-term or long-term disability benefits. It's the test that essentially your health prevents you from doing the key duties of your job at the time that you became unwell and had to stop working. And really, I think it's a misnomer to some extent. And John, we talk about this quite a bit, because total disability, it evokes in your mind that you're laid up in bed, that you can't do anything.
Can't feed yourself, can't go to the bathroom, can't walk, you're done. Done.
That's exactly right. And it's not the case whatsoever. In fact, it's really actually just lining up what are the key things that you're doing in your employment with the key things from a health perspective preventing you to meet those essential duties. And it's not even everything, it's the key things. That's really what the test says. And so, look, when you're thinking about total disability, this is the conversation to have with your doctor. Is your doctor saying you can't work as a result of your health? If the answer to that is yes, that's total disability. Let's keep it very, very simple. Insurers, of course, want to make it seem it's a lot more complicated than that. It's not. So if you're listening to the show and you're thinking, well, I'm not sure, am I going to meet the test of total disability under a policy? It really is actually a medical question in my mind, less so to be a legal question or even a contractual question. It really comes down to, if there's support that your health is preventing you from working, that triggers the test to qualify, and you should then, it should flow from there in terms of getting disability benefits, short-term or long-term.
Yeah, we often talk about, for an example, a surgeon or a concert pianist, right? They have severe burns on both hands. They can still walk, they can still talk and function and possibly feed themselves without assistance, but they can't do their job. They would be classically totally disabled from their gig for a time being anyway, right?
Absolutely. And so let's think of a very common example. Think about a situation where someone is working, in a client-facing type role, and then they develop mental health conditions, and conditions that really bring on a lot of anxiety. You can't really socially interact. You're having a lot of health conditions that get triggered potentially from actually having contact with people. It doesn't mean that you can't have, answering phones or typing an email. But if your key function in your role is actually client-facing, and your health is preventing you from doing that key function, that's total disability, and you should be entitled to disability benefits. Look, do I think that insurers have come some way in this analysis? They have. But let's not forget, at the end of the day, John, if they decline more claims than are approved, then they get to line their pockets, and this is a profit model that they get to drive. And by the way, let's not forget, they also write these contracts. It's their definition, and they put their own people to interpret those definitions. So look, could it be that it's stacked against you? It's possible, but it's actually a lot simpler than we give it due. And it doesn't have to be as straightforward as a broken arm with a concert pianist. It can be a lot more nuanced, and the courts have recognized that that nuance is also compensable.
The second of 3 LTD terms you got to know is own occupation. Break that one down.
So look, we talked about this a little bit when we talked about total disability. Total disability actually has 2 tests in most disability policies. We have the own occupation period and then the any occupation period. But you asked me about own occupation because frankly, that's the one that most people are dealing with right out of the gates. So you make your application for disability benefits, and the insurer, the adjuster, is going to look to see whether or not you were totally disabled from the occupation, the job that you were doing at the time you became unwell. And so having a very clear understanding to your insurer about what those occupational duties are, very important. I've seen this happen a few times, John, where someone may have been on a path of modified type work before they started their disability claim. Right. And so does the modification have to be taken into consideration? Sometimes yes. Sometimes it depends on how long you've been doing that modified position before you were put off work. But at the end of the day, from the adjuster's perspective, they are looking to see what is your own occupation on paper, what are those job duties, and are you prevented from doing those job duties as a result of your health? Very straightforward. And that own occupation period in most policies is for 24 months or 2 years. Now, this doesn't mean that you only get benefits for 2 years, folks. This just means that in that first phase of your long-term disability claim, what the insurer is going to be looking at is, can you meet your own occupational duties? And if you can't, then your disability benefits should continue. It's only after those 24 months of payments or 2 years of payments that the test to continue to qualify changes. It then becomes, are you totally disabled from any occupation? And John, I could talk the whole show about the any occupation test.
I know.
But really, that's where we see the heart of a lot of disputes with the disability insurer is at that any occupation phase, because that can go from the moment that switches over from that 2-year mark all the way until someone turns 65 years old.
Yeah.
If you're in your 40s, that's a long time.
You bet. Third term, LTD term you got to know is recurrent disability, right?
So we talked about this a little bit in our prior segment. What is recurrent disability? So most disability policies will have a section that says if your health issues recur while you've returned back to work, and it's within a period of time after a prior claim, you can access that disability policy again and get benefits paid for again without having to wait for the period of time in which you needed to wait, probably at the start of your disability claim. Let me explain it in a different way. Let's say you've got a series of health issues. You received appropriate treatment for those issues. You were on the path. You received disability benefits, and then you were ultimately cleared to get back to work. Once you received that medical clearance, you coordinated to get back to work, and you started your job, perhaps accommodated, perhaps not. It doesn't really actually matter. What matters is it's a window of time. And in that within usually 6-month window, if your health prevents you from working again, you go right back onto claim in theory. But of course, disability insurers like to resist these types of claims. And so they like to embed a lot of language and caveats around whether or not your claim is actually a recurrence claim or a new claim. Either way, if you're not sure, we're just a phone call away. These terms can be really technical, can be really challenging. Most people have never dealt with a disability insurer before. This is why we have a great website, ltdfaq.ca.
Yep.
There's a series of memos, and one of them talks about commonly used terms. So if you get a term lobbed at you by your adjuster and you're not sure what it means, please don't hesitate to access that website. It talks about own occupation, recurrent disability, any occupation, and a whole series of other terms that you might want to unpack because you're not really sure what is it that this adjuster is saying to me.
Again, ltdfaq.ca. Tamar is right. You can use that freely and anonymously, of course, like every other website. Okay, you've been denied LTD. You're about to lose your gig. What happens next? We'll cover that on the Disability Law Show. Stick around.
People think contractors aren't owed severance. EmploymentLawyer.ca says that is a myth. Many contractors are actually employees and are entitled to full severance pay. Always check with the employment lawyer first at EmploymentLawyer.ca. How do you force insurance companies to pay long-term disability claims?
Insurance companies deny legitimate claims all the time. They're playing the odds. They know that most people are just going to walk away.
Your insurer may ignore you. They may even ignore your doctors, but they can't ignore us.
We know how insurance companies work. We know their weaknesses. We know how to use the legal process to force them to pay you what you're owed.
Go to disabilityrights.ca. Discover your rights, fight back, and get what you're owed. People think you are only owed 2 weeks' pay when you lose your job. EmploymentLawyer.ca says that is a myth. You may be owed much more than 2 weeks per year. Don't settle for less. Always check with the employment lawyer first at EmploymentLawyer.ca.
Welcome back, Disability Law Show. I'm John Scholes, along with Tamar Agopian, Samfiru, Tumarkin, LLP, the most positively reviewed law firm in the country. Reaching out is really simple. I'll give you the phone number, 1-855-821-5900. Yet another website for you to use. It's free and anonymous. This one you can actually take part in and ask questions. It's called mydisabilityquestions.com. Check it out, use it, and your questions will be answered. Again, they may appear on a future show. Raj is writing in here. Tamar says, a few months back, I was badly hurt in a slip and fall at home, and my back has not been the same since. My employer refused to provide accommodations in my job, which only made my injury worse, to the point where my doctor said I can no longer work. My attempts to get LTD have failed. They don't think I'm totally disabled. Now my boss says there is no value in keeping me. That's nice. What should I do?
What should I do? So, Raj, we talked about this a little bit earlier in the show, that there's so much intersection between disability law and employment law. This is why we're so well suited to handle matters like what Raj is describing, John, because it's not actually that straightforward. You're thinking about, look, I'm stuck between the disability insurer who's saying, no, I don't qualify for benefits, and an employer who's resisting me having to come back to my job or helping me to accommodate my disability. So overwhelmingly, I mean, I'd want to deeper dive a little bit with Raj about what's happening from a health perspective, but overwhelmingly, if your doctors are recommending that you not work as a result of your health, that's your starting point. You really don't want to be dealing with the employment issues if, in fact, the advice medically is that you shouldn't be working. In my mind, I'd want to assist Raj in challenging the disability insurer with a legal claim to actually get those benefits approved and paid for a period of time, and then we can revisit what's happening with the employer. Because, look, if it's a totally disabling claim or health issue, which it certainly sounds like it is, the benefits should be approved and paid. The fact that they haven't up to this point concerns me, John. Yeah. And then you layer on top of that what he's being told by his employer. The employer has a duty to accommodate, and that duty to accommodate is to the point of undue hardship.
That's right.
Now, is that a clear-cut delineation in law as to what undue hardship means? No, not necessarily, and it can be a case-by-case analysis, but in my mind, there's not a lot of wiggle room here, John. I mean, he's clearly got some health issues. He clearly requires that accommodation by the employer, and to be told, hey, you're not good, you're not well enough, I'm going to throw you, on the side of the curb, or we're not going to have you back. Yeah. That could be potentially breaching Raj's human rights, obligations.
Sure.
And so, look, I think the employer might be in a lot of hot water in a situation like this. I would want to do a little bit more analysis, but at the end of the day, I think there could potentially be two claims here, one for disability and one for the employer down the road.
Let's get to Emma's email rather quickly.
Absolutely.
We've got a couple minutes to go. It says, I've been an LTD and CPP disability for almost 3 years with fibromyalgia and arthritis. My insurance provider is requesting I attend a mandatory medical assessment with a recommended doctor. My own treating doctor says I'll likely not be able to return to work for years to come. Do I still have to attend?
Unfortunately, Emma, yes. Unfortunately, that's the case because most disability policies will have a section that says if the insurer requires you to attend an IME, an independent medical examination, you are required under the policy to attend. Lots of other information I can provide in respect of the IME, but at the end of the day, the short answer is yes, you have to attend and go through that process with the disability insurer to see what it is that's going on from a health perspective and have the insurer assess you by their doctors and provide an opinion.
But even with that assessment, don't discount the validity of your own medical team. This could be a doctor that's never seen you before.
100%,
right?
And so critical. Make sure that your own doctor is providing clear, unequivocal medical information, supplying that to the disability insurer about where you're at from a health perspective so that you've got your own medical info available to the insurer as well as what the IME doctor may come back and report on to the insurance company.
And she's also on CPP disability, which is a good thing. Tougher test,
Absolutely.
arguably, right?
Absolutely tougher test, but also another log on the fire that it certainly looks like her health issues are severe and prolonged.
Guys, appreciate all your input for the show today. We will continue next week. Keep sending those emails along. Keep making those phone calls. You want to reach out to Tamar, you always can. 1-855-821-5900, help@disabilityrights.ca, and that website, right, mydisabilityquestions.com. So good to have you on the show, watching the show, and we'll catch you next time. This is the Disability Law Show.